represents teachers. This is not an easy question. First of all, with all due respect to any other contracts, teacher contracts are different in the state of Connecticut than any others, because there is a number of parties to the contract. There is, of course, the Teachers Association, the union, the Board of Education, the town government. The town government has responsibilities to be consulted under the Teacher Negotiation Act. Members of the town council can be present and have been present during negotiations. The state of Connecticut is in the room as well. The teacher negotiation is a preemptive law which requires that certain processes must take place at specific times, in spite of whether the parties want them to take place or not. And the parties can be subpoenaed to force those processes to take place. They're called mediation, binding arbitration, and the question is, are there risks to opening a contract? And the fact of the matter is, there are. To the degree of risk is a matter that the parties must make, but we cannot advise our clients and say we can create a system where there is no risk. And if anyone wants to see where those risks are, contracts have attempted to be opened, and they're now in the courts. And one particular contract is the community that I happen to live in, and that is Guilford, Connecticut. They attempted to open the contract. It was not submitted for proper ratification to the town council or to the Board of Selectmen in that town, which is their charter form of government. And now we're awaiting a declaratory judgment from the court as to whether that procedure is flawed. And we believe it is flawed. So to open a contract or to grant furlough days or whatever the concession may be brings to these people in this room, these teachers, significant risks that may cause other adverse financial conditions to them, and does create the opportunities for certain members of any community who wish to seek a remedy in the courts that could force the implementation of these other processes that I just mentioned, which takes control away from the parties. Now, as to the furlough days, or to the promissory days, first of all, it was not a promise to be paid next year. They offered a 5-year promise, and it could have been longer. And why was that offered? Because of all the possibilities, it was our legal opinion that this had the least risk, that it involved the least risk for the statute. Because the statute governs everyone in this room. We cannot avoid it.